The Michigan is now back in session. The opportunity today subject to the
You may be seated. Court does call the case of the people versus Lisa Keebler.
John Shea, Your Honor, with and on behalf of Ms. Keebler for sentencing. May Ms. Pilara and I approach briefly?
You may.
Your Honor, I did want to make the court aware that I do know Ms. Keebler from a prior work relationship, which we did have some social events that we had while that was taking place. I did want to make the court aware of that. However, I don't believe that my recommendation to the court is impacted in any way. I believe that the recommendation that I provided to the court would be like any other probationer that came. And that those events happened a while ago, a long while ago.
Not wanting to age oneself, you're just saying a while
That's
ago.
correct.
Okay, all right. And I will just say that I had previously disclosed in taking the case that I also know Ms. Keebler. And we had a working relationship, both the state prosecutor as well as defense counsel saw no issue with this court proceeding with the case, given that. I would also say that I would have known and knew in the past that there was a working relationship as between Ms. Pilara and Ms. Keebler. And I would expect nothing less from Ms. Pilara, and she has never disappointed me that she would not let that affect her in any way. And certainly when I look at this recommendation, it is a standard recommendation and does comport with this court's manner of sentencing in these types of cases. So unless there's an objection from the defense in that regard.
I didn't object then, and I'm certainly not objecting now. I think the court's correct in its characterization of the recommendation, and I appreciate Ms. Pilara putting the disclosure on the record.
All right, go ahead.
Your Honor, we have reviewed the recommendation. We've also reviewed the assessment that accompanied the recommendation, including in the conference room today, but also prior to this. We, with the exception of, and then we discussed this at the bench, Ms. Keebler needing some accommodations when it comes to alcohol treatment, which we discussed, don't have any other comment really with respect to the recommendation. It is as I would have expected, and I explained that to Ms. Keebler. So we're prepared for the court to proceed forward accordingly.
All right. Ms. Keebler, is there anything you'd like to tell the court before I impose that?
Your Honor, how do I adequately apologize for being in front of you today? If anyone knows better, it's me. I want to thank you for overseeing my case today. This has been an incredibly humbling experience, and I promise you will not see me in this capacity again. Thank you.
Thank you, Ms. Keebler. You know, and I'll just say, people certainly can find themselves in difficult circumstances, but I think that much of it, sometimes behind the scenes, the way you have, at least the time that I've known you, served the people of Washtenaw County, mistakes can be made, right? But it doesn't by any means diminish the service that you give to the people here. This court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of IOP treatment, attendance at weekly AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. This is therefore the sentence of the court that I will place you on 18 months probation. I will order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, and $540 probation oversight fees. When can that be paid?
I can pay it today.
Thank you. It will be paid today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. It will be subject to random testing as requested by probation. You are to complete an intensive outpatient substance treatment, including all recommended aftercare with status reports to probation. I will just note in that regard that much like with any defendant, that where an accommodation is required, we will provide that accommodation for the defendant.
Thank you.
You are to attend 2 AA meetings per week with monthly verification to probation. You provide proof of victims impact panel attendance to probation. I will continue to scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. Up to you, Ms. Katie.
Thank you.
Thank you, Judge.
Thank you. Court does call the case, People versus Edward Harris.
All right, let's talk about that. The sentencing hearing was all about transparency, rehabilitation, and the professionalism of a courtroom that knew how to handle personal connections without compromising integrity. Lisa Keeble's case brought with it some pre-hearing disclosures. Both the probation officer and Judge Simpson had prior working relationships with Ms. Keeble. But here's the thing, rather than sweep that under the rug, both made it crystal clear on the record. Ms. Polera, handling probation, assured the court that her recommendation was unaffected by any past association, and Judge Simpson backed that up by noting the sentencing proposal was exactly what she'd expect for any probationer in a similar case. It was the kind of straightforward candor that reinforces public trust, not undercuts it. Defense counsel didn't object, and everyone seemed to agree. The recommendation was standard, fair, and aligned with the court's practices. The defense did request one, modification and accommodation for Ms. Keeble's alcohol treatment, which was discussed in chambers and acknowledged in open court. The judge, staying fully in command of the moment, addressed everything head-on and cleared the way for a smooth sentencing process. Then came Ms. Keeble's chance to speak, and what followed was one of the more sincere courtroom apologies we've seen. Her words were simple and direct. If anyone knows better, it's me. No excuses, no theatrics, just gratitude to the judge and a promise not to be back in front of the court again. It was a quiet moment, but an impactful one. Judge Simpson responded with equal grace, acknowledging that while people can find themselves in difficult circumstances, prior public service doesn't vanish in the shadow of a mistake. The court emphasized that while this was not a statutorily serious misdemeanor, it did warrant a structured probation. What followed was a detailed sentence rooted in treatment and accountability. 18 months of probation, over $1,500 in combined costs and fees, a continued SCRM tether for 30 days in lieu of jail time, required meetings, outpatient substance treatment, and a victim's impact panel. Ms. Keeble confirmed she could pay the fines immediately, another indication that she was ready to take responsibility and move forward. The tone throughout remained calm, respectful, and focused on rehabilitation. What stood out most here wasn't the charge or the sentence. It was the professionalism on all sides. Disclosures were made transparently. No one took advantage of prior relationships, and the defendant came prepared to face the consequences with maturity and humility. Judge Simpson ran the hearing with balance and clarity, reinforcing the message that fairness doesn't falter even when familiarity is part of the courtroom. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.